Hi, my name is James Cella. I'm the Chief Supervision Evangelist here at Red Oak. And today I'm joined by attorney Brian Rubin. Brian, great to have you here with us. Can you give us maybe just a brief introduction of yourself?
Sure. As you can see, I'm situated in the middle of the tidal basin in DC. I am a partner with Eversheds Sutherland, which is a global law firm. I'm co-head of the Securities Enforcement Group. I used to work at SEC Enforcement, and I was also Deputy Chief Counsel of Enforcement at NASD, FINRA. And my primary practice is representing firms being examined and investigated by the SEC, FINRA, and the states. And AI is my frenemy at this point in time.
Awesome. And we're hoping to dig a little deeper into your frenemy relationship with AI. And so we're really grateful to have you join us. So today we're going to be talking about AI in a regulated environment, specifically with the legal perspective that Brian brings to the table. So Brian, you spent your early part of your career in the regulators chair at the SEC and FINRA, which was NASD at the time. And the last 2 decades on the other side of the table representing firms in enforcement. So when you read headlines about AI in financial services right now, what does that combined vantage point, having seen both sides of the equation, what does that sort of mean to you? And sort of like, what is that, sort of revealing itself, certainly in these early stages of AI?
Yeah, I think the big point is that regulators have been applying and will apply existing rules to AI. So, having sat on both sides, I can see the enforcement cycle is already forming. Someone only on the regulatory side might not fully appreciate how quickly firms are adopting and using AI, and somebody who's only been on the industry side might not grasp how the regulator's going to sort of dust off their old traditional rules, supervision, record keeping, communication requirements, and hold firms accountable. And the lack of regulatory issues or rules at this point could be a trap for some people, but just because there's no specific AI rules doesn't mean that enforcement isn't coming. And off-channel communications is a perfect example. You had new technology like texting and WhatsApp, and firms were being penalized using the old existing record keeping rules. So I expect we'll be seeing similar kinds of things.
So, kind of digging into that a little bit more, uh, it seems very clear that regulators are still using, in some cases, paper-based or rules that were based upon paper or memo communications or letter communications, certainly non-digital communications when it comes to AI. Is that what you're seeing not only on the regulatory side, but as far as how firms are trying to react to AI?
Yeah, I think that's fair, and the books and records requirements are a perfect example of that. But as I said, I think from the regulator's perspective, they are seeing that their existing rules still apply to AI, to digital issues, and firms should be aware of that.
Okay. So there's a long-running pattern in financial services where regulators don't often write the rules to keep up with new technology. Though we've seen recently that FINRA is really trying to make those updates with some of the announcements they made last year. But sometimes we see these rules, they won't be applied until years after the fact. So where do you think AI sits in the cycle right now? And what would you tell a CCO who is trying to plan around that sort of level of uncertainty, especially, considering the broad scope that AI now brings to our environment?
Right. At this point, AI is firmly in the existing rules apply phase, which is historically potentially risky for firms. AI tools are widely adopted, but there aren't specific AI rules. And as we talked about in the past, when there have been technological changes like with email, social media, texting, that sort of thing, there's rapid adoption, a period of regulatory silence, and then enforcement actions using the old rules. And I think that's what we're going to be seeing now. So that means CCOs should not wait for bespoke AI rules. Both the SEC and FINRA, as you mentioned, have been signaling attention through exams and guidance. And that's what we'll see. And the final point for CCOs is the firm's mantra for AI should really be governance, 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 because you've got to build the AI oversight framework right now, and I know we'll get into a lot of those issues, but you need the processes in place before you adopt the AI. And also, you shouldn't overlook things that you already have, like your incident response plans. They should contemplate AI-specific scenarios like hallucinations, data leakage, that sort of thing. And the goal is to show the regulators that the firm acted reasonably before enforcement expectations are ultimately fully crystallized.
So you co-authored the NSCP firm and CCO liability framework. Can you tell us a little bit about that?
Yeah, so the framework was meant to help the regulators, and the SEC and FINRA have been using it to focus on what CCOs are and what they aren't. And in general, they're not supervisors, they provide advice. So in this context, and I think we'll talk about it,
Yeah.
although CCOs are going to be intimately involved with their firms, they're going to be part of a management team, and they likely won't have the power of the purse. They likely won't be able to hire and fire at will, but they will be playing an important role in providing the compliance advice. And ultimately, they should be able to distance themselves and say, I wasn't managing the process, but I was involved with it.
And so AI does really sort of intensify that level of exposure or potentially intensify that level of exposure then.
Sure. Yeah. Whenever you're dealing with new technology or new issues, and in particular AI, because it's so fast moving and so vast in terms of what it's able to do, there are potential firm and possibly individual liability issues.
Have you had CCOs approach you and talk to you about some of the concerns about personal liability when it comes to AI systems and having humans in the loop? Or what sort of advice are you giving them, I guess?
Yeah, so a little bit. I mean, I think CCOs are mainly interested in the governance type issues, setting things up. I think at this point, we haven't seen any cases. I don't think they're that concerned about CCO liability. But, obviously, the CCOs don't have to be coders. They're part of a team. The members of the team have various expertise. So the teams are going to involve compliance, legal, IT, business leaders to review and approve the uses of it. And CCOs are going to play a fundamental role, like they always do, in asking key questions. The liability could increase if there's a material problem and they know about it and they fail to act. And the best protection for them, like in all scenarios, is to document what's happened.
Right. So, without naming names, of course, what kind of AI related compliance failures are starting to show up in your scope, in your purview? What are some of the matters and things that you or your colleagues are asked to defend?
Well, we haven't defended yet, but in terms of what the examiners have been looking at, the first issue is exaggerated AI claims and then related operational governance. So things like AI washing, bad content, overstating what AI does or how central it is, overly optimistic language, that sort of thing. And it's worth noting that the SEC has brought AI washing cases using its marketing rules and the anti-fraud provisions. And then the related operational failures include AI generated communications going out without reviews, records not being retained, surveillance outputs being ignored. We're also seeing analogies to prior enforcement issues. So, one example is books and records.
Mhm.
Firms use AI meeting assistants to record, transcribe, summarize calls,
Right.
and then firms may not have adequately considered record keeping and supervision issues. Another issue, again analogous, is unauthorized use, like with the off-channel cases. So employees may be using public AI because they may not like what their firm has, or their firm doesn't have sufficient tools. So they're plugging in client data into public chat box, creating confidentiality issues, books and records issues, that sort of thing. And the last issue is MNPI and PII. AI has access, for example, to internal research, deal information, client trading, confidential information. And the problem is if there's leakage or the information is moving from one channel to another channel. And again, all of this is consistent with issues that we've seen before. The technology is new, but the compliance risks aren't really that new.
Do you feel like regulators have done an ample job of sort of warning warning your clients as far as what they should be looking out for when it comes to these sorts of things?
Yeah, there's not going to be any gotcha issues. I think the regulators are grappling with the same issues that the firms are. The regulators have been putting out guidance, making speeches, that sort of thing. So I think for the most part, the regulators and firms are on the same page with regard to what kind of potential issues there are. No doubt the regulators will end up focusing on something that hasn't gotten a lot of publicity at some point in time. But that's just natural and that's going to be expected.
Yeah, for sure. So I guess as we kind of wrap up a little bit here, if a CEO came to you tomorrow and said, "Hey, our firm is about to roll out an AI system and as part of our new business initiative that does touch compliance. What do I need to do to protect myself, the firm, and our clients when it comes to this? What sort of advice would you give them?"
First, I need an engagement letter and big retention from them. But
Yes, you do,
assuming
Esquire.
that's already in place,
Yeah.
the first issue is that various parts of management and compliance are going to have to get involved before there's launch at all. So AI isn't just an IT project. You need governance, you need compliance, legal, technology, business. All with a documented approval process for use cases. And since we're talking about CCOs, and we talked about CCOs before, the message for CCOs is they should be providing advice, not supervising. The second issue is building the process before the tool goes live. So you want written policies, approval use, diligence, testing, training, auditing, monitoring, all of that stuff. For CCOs, the question that CCOs may not be thinking about right now is what am I going to tell an examiner and show an examiner 2 years from now when I get examined? So the rollout really has to have a clear record of who was involved, who approved it, how it was tested, how the outputs were reviewed, how issues are escalating, all of that stuff. And then the final advice that I would give that I talk to compliance and executives at firms all the time is championing the right culture. So
Hmm.
you've got to train the employees about what AI can do and what it can't do. So emphasizing that AI is really a helper, not a decision maker. It's not infallible. It shouldn't be used as a crutch. You have to foster a culture that views technology through a compliance conscious lens.
And are you finding that CCOs and InfoSec and IT folks are coming closer and closer together with a lot of these things,
Yeah, I think
or
they
having to
are.
interact a lot more?
Right. I think they are. And when we've been dealing with cybersecurity issues in the past, they've also been working closely. So I think this is just a continuation of how technology is impacting firms, and the firms should be working together as a unit or as a group trying to deal with these issues.
Absolutely. Well, thank you so much, Brian. This has been very interesting, and thank you so much for the wonderful conversation as we've gone through this. So we're going to wrap up here, but we will be having a deeper dive into this topic with a few other panelists in an upcoming webinar. And we look forward to seeing everyone soon. And again, Brian, thank you so much for joining us today.
Thanks, James.
Thank you.